Today, almost 16 months after Trayvon Martin was shot and killed, opening statements began in Sanford, Florida, in the state of Florida versus George Zimmerman. With great anticipation, MSNBC was ready to broadcast live the prosecution's opening statement.
Good morning. Punks. These they always get away. Those were the words in that grown man's mouth as he followed in the dark a 17-year-old boy who he didn't know.
It's a stark reminder of the alleged conditions under which Trayvon Martin lost his life on the night of February 26, 2012. The prosecution says George Zimmerman spotted Martin as Martin was on his way back to the neighborhood after having bought an Arizona fruit drink and some Skittles. Zimmerman says he tracked Martin and followed him after immediately finding Martin's presence suspicious. Zimmerman called police and apparently ignored the dispatcher's advice to meet the police at the mailboxes in the neighborhood, according to calls to be submitted by the prosecution. At the end of the subsequent encounter between Zimmerman and Martin, the 17-year-old Trayvon Martin was dead. And there is no dispute in this case that George Zimmerman was the man that shot him. The case hinges on whether George Zimmerman acted in self-defense, as he claims. Zimmerman has not pleaded guilty.
There was this defendant riding around in his car, not with candy, not with fruit juice, but with a Kel-Tec 9mm semi-automatic pistol in a ready-to-fire position, meaning there was one live round in the chamber.
For its part, the defense, to back up George Zimmerman's not guilty plea, just a few minutes into its opening, did this.
Knock, knock. Who's there? George Zimmerman. George Zimmerman, who? All right, good. You're on the jury. Nothing? That's funny. After what you folks have been through the last 2 or 3 weeks?
After later apologizing to any juror who might have been offended, the defense offered several refutations to what the prosecution might show with its evidence, including the question of who was armed and who was not.
If I've heard it once, I've heard it 1,000 times, that Trayvon Martin was unarmed. What the evidence will show you is that's not true. Trayvon Martin armed himself with the concrete sidewalk and used it to smash George Zimmerman's head.
This is security camera footage of Trayvon Martin at a 7-Eleven on the night of his death, bringing his items to the cashier. This afternoon, the prosecution began establishing a foundation with its first witnesses, calling that cashier at the 7-Eleven and the dispatcher who took George Zimmerman's call. And a disclosure, of course, before we proceed, George Zimmerman has sued NBC Universal for defamation. The company has strongly denied the allegation. Joining me now, Craig Melvin, who's covering the Zimmerman trial for MSNBC. And Craig, what was your takeaway from this big action-packed first day in which we finally got opening statements and we even saw witnesses on the witness stand?
Yeah, you know what, Chris, I'd say it was probably just the sheer contrast between the two approaches to those opening statements. You played a clip there, a clip that we've seen a lot of today. The state came out the gate about 33 minutes. They started with using the words that George Zimmerman used, words that we can't use on our air, but there was a great deal of profanity used today. So we had the state, and then they sat down again after about a half an hour. The defense gets up and they go for about 2 hours, 45 minutes. And in addition to that knock-knock joke, the jurors were also subjected to a fair amount of looking at these detailed diagrams of that gated condo complex. And then there was a great deal of time spent looking at the timeline for that night. They took a lunch break, then they came back, and the defense continued. So I would say just the juxtaposition between those two opening arguments. You mentioned Judge Nelson. Tomorrow morning, before the jury is brought in, we will hear Judge Nelson's ruling on whether the state will be allowed to bring in 7 additional calls that Zimmerman made to that non-emergency number. So again, that'll happen tomorrow morning at 8:30. Then after that, the defense will continue calling additional witnesses. For today, we expect several more tomorrow, Chris.
MSNBC's Craig Melvin, thank you so much. Joining me now is Maya Wiley, former Assistant U.S. Attorney and founder and president of the Center for Social Inclusion, a social justice nonprofit. Josh Dubin, a jury and legal consultant, founder of Dubin Research and Consulting, and Michael Eric Dyson, MSNBC political analyst and professor of sociology at Georgetown University. Great to have you all here. Josh, let me start with you. So you've worked on cases in Florida. You do jury selection consulting. So what do you want, as the prosecution and as the defense, on their first day, the chance to make the first impression in a case like this? What do you want to establish with those jurors?
Well, the first thing you want to establish is the right tone, okay? And so much of being a great trial attorney is being able to establish a rapport with the jury. And I can tell you from the outset that I think the defense fumbled in a big way. I think that in a case where the deceased family is sitting 10, 15 feet away from you, to tell a knock-knock joke in a case as serious and that has received the type of exposure that this case has received was a huge mistake. Conversely, I think the prosecution hit a home run. I think they had the tone just right. I think that throughout their opening statement, they echoed the extreme nature of the case.
So one of the things here legally, I just want to, I know a bit about the law. My wife is a lawyer, so I get some sort of osmosis about the law. But as a non-lawyer, if I'm sitting in that juror's box, right, it's an interesting case from a certain perspective because there's not a dispute about who shot who, right? I mean, a lot of times what you are trying to establish in a murder trial is, was this a person that fired the gun? And there's forensic evidence about whether they did or not. And there might be eyewitnesses. That's the thing the prosecution's, that is not the issue here, right? The issue here is what, Maya? It is self-defense. What does that mean legally?
Well, legally, of course, the issue is whether or not George Zimmerman had some reason to believe that he was in danger of being harmed seriously and therefore had the right to defend himself, and in this case, with deadly force. You know, I'm not an expert on Florida law. I'm not going to pretend to be, but it seems to me that that's part of why you're hearing that opening you heard from the prosecution, which I absolutely agree with Josh, was a home run, because what they were saying is they were painting the picture of a predator, not painting a picture of a guy who was afraid. And that is pivotal in a case that's a self-defense related case. I
want to talk to you, Michael, about how this trial finally happening intertwines with all the attention it's received and what that kind of feedback loop between the courtroom and the attention it's getting outside looks like right after we take this break. Here with Maya Wiley from the Center for Social Inclusion, Josh Dubin, a jury and legal consultant, MSNBC political analyst Michael Eric Dyson. We're talking about the first day of the George Zimmerman trial. And Michael, given the buildup there's been, given the intense attention that we've all paid to this trial because of the just wrenching facts of the matter and their sociological implications for what it means about race and justice in this country, what was your reaction to these first day's arguments?
You know, that's a great question. I see it as a father, too. I got 3 kids. And I tell you, it devastates me to believe that in this day and age, what I believe to be the cold-blooded murder of a young boy has to be adjudicated in such a fashion that it becomes nearly bloodless, the complete opposite of the contested nature of that night. Right. So now, you know, Zimmerman is portrayed as, and he deserves a trial and he deserves his day in court, but the reality is that, you know, the construction of these young black kids, if the attempts to kind of demonize and portray this young man as somehow aberrant and somehow against the norm of American society, what does that say about the millions of kids? And
that was what was so, I thought, brilliant and effective about the prosecution's opening line, opening with that line, the reminder of that line from the tapes, infamously, about the judgment that emanated in that moment, in that one moment, by George Zimmerman on tape about, as he said, the
racialized judgment.
And a racialized
it's not
judgment.
A race-neutral judgment.
No.
It wasn't just the blanking punks.
Right.
And George Zimmerman is a man who called the Sanford Police Department 46 times to say there was some scary black person in the neighborhood, so there's also
the question here, I think, also is it goes to how the jury is going to process all this, and there is in jury selection, we know, tremendous racial effects in jury composition, and how juries process this, particularly because our criminal justice system is intensely racialized, and this case has been from the moment an intensely racialized case. What is your experience in thinking that through as a jury consultant?
Well, look, you have to pay attention to a few things. One, one is you have to be real about the fact that people are prejudiced. People have biases. When you start with that proposition, my tact and my philosophy is always to try to get people, they all come in like this, and you want to just try to get their guard down and try to get them to be comfortable with saying, yes, this is the way I feel about this minority. Here's how I feel about this issue. That's the challenge. As far as the group decision-making dynamic is concerned, you look at the composition of this jury. You have 5 white people and 1 person, and there's been some dispute.
Person of color.
Person of color.
Right.
That makes a big difference, because I've had cases that have nothing to do with race whatsoever. An accounting fraud case where it was an all-black jury and it was 1 white man and there was 2 white defendants, and we get a note in federal court in Manhattan saying, I feel like I'm being ganged up on because I'm white. That happens. And the group decision-making dynamic in Florida in state court is even more compromised and even trickier, because there's a 6-person jury here, which is astounding to me, that from the standpoint of this man's, look, we could all have our feelings about, he deserves not only his day in court, he deserves a fair trial.
Absolutely.
And he deserves not to be judged unless and until all the evidence is in. Okay.
Right. But here's the point, that people of color have been told that we have abided by that when we knew the murderers were out there. When Byron De La Beckwith was running around with reckless glee, celebrating the fact that he killed Medgar Evers. So that's not that long ago. If Paula Deen can be excused because she's of that generation, imagine how many Paula Deens are in this world who sit on juries who make decisions about the future of our children. And you're right.
Well, the screening process, presumably by a competent attorneys, is to try to make sure that doesn't happen.
But the jurors
so there's it does matter if this 1 juror of color is black or Latino, because the evidence on implicit bias, which is what we're really talking about, not people consciously saying it, is if people who are Latino are just as likely to have implicit bias against blacks as people who are white. So it matters.
So we are doing this tallying, of course, because what we know about this jury is simply this fact. Maya Wiley from the Center for Social Inclusion, jury consultant Josh Dubin, MSNBC political analyst Michael Eric Dyson. Thank you.